Now, as you know, our subject is named as corporate law. Right? So, under corporate law, basically we are discussing about the Companies Act. Right? Now, the prevailing law related to companies is number 7 of 2007. Basically, we are considering the provisions contained in the Companies Act. Right? Then when we consider the concept corporate company under corporate law, right, first of all we have to identify what is the company. Right? Then thereafter we can consider the provisions contained in the Companies Act. Right now, before come to companies, right, we can identify there are two types of persons recognized by law. Right? There are two types of persons. So how we can classify the persons? Yes, yes, we can classify the persons as legal persons, right, and natural persons. So that is the classification, right? Natural person and legal person. Right? Natural persons means human beings, like you and me, human beings, and legal persons. This is another concept. They are created persons. Right? Artificial legal person. Right? So when we consider the legal persons, actually we can create legal person by two methods. Right? One method is Parliament can bring an act, right, declaring a particular establishment as a legal person. Right? Anyway, right, any time Parliament can bring an act. There are several organizations established under Parliament Acts, right? Like Bank of Ceylon, People's Bank, YMPA, right? People's Bank. So these are the organizations which are established by Parliament Acts. Right? And the second method is we can create a legal person by registration under the Companies Act. Right? Registration under the Companies Act. Right. So now our subject is corporate law. Right? So under corporate law, we are going to consider how to create a legal person by registration under the Companies Act. Right? So basically, we are considering, right, the provisions contained in the Companies Act under the corporate law. So that is the way how we come to corporate law. Right? So now, suppose that you are going to incorporate a company under the Companies Act. Right? Then actually there are several steps to be taken. Right? So you are incorporating. Now you are going to create this legal person by registration under the Companies Act. Then actually we have to submit, right, some documents to the Register of Companies. Right? Register companies. Right? So first of all, we can consider those documents, and thereafter we will discuss. Right? Right? So what are the documents to be submitted in order to incorporate a company under the Companies Act? Right? Basically, we can identify there are 5 documents to be submitted to the register of companies, right, in order to incorporate a company. Right? So now, when we consider the documents, right, we can identify 16A, and another document is Form 1, and Articles of Association. And another document is Form 18 and Form 19. So these are the documents to be submitted to the register. Right. Now, according to the Companies Act, there are 3 main types of companies can be incorporated. Right? We can identify there are main 3 types. Right? What are they? What are the basic types of companies? Sorry? Private company, then the private company, public company. Okay. What else here? Sir? Limited by guarantee. Very good. Company limited by guarantee. Yes. What else? Huh? Types of companies. Private company, public company, company limited by guarantee. What else? Right. Good, good. Right. Now, basically, we can identify 3 types, right? That is, this is another classification, right? Uh, right. The first type is limited companies. Then the second type is unlimited, right? Unlimited companies. And the third type is company limited by guarantee. That is the third type. Right? Now, you told me private and public. How we can come to public and private companies? Now, here, limited companies, we can divide into 2. Right? Further classify limited companies as private and public. Private, public. Understand? So, limited companies, we can further classify it as private and public. Then the public companies, we can further classify, right? We can further classify it as listed and unlisted. Listed, unlisted. So that is the classification. Right? So these are the so listed and unlisted. Listed and unlisted. So this is the classification. Right? Limited companies we can further classify it as private and public. Public companies can be classified as listed and unlisted. What is the meaning of listed company? What is the main feature of a listed company? They can trade their shares in the stock market. Right? They can trade their shares on stock market. Right? So that is the main feature. But if it is an unlisted company, they don't have such rights. Right? They cannot trade their shares in the stock market. Right. So this is the classification. Right. Then apart from these, actually another, basically we can identify these companies can be incorporated under the Companies Act. Apart from these, another two types we can identify. They are known as offshore companies and overseas companies. Offshore companies and overseas companies. Offshore can apparel සමාගම් කියන්නේ අපි ඒක පස්සේ කරනවා like apparel සමාගම් offshore company. And overseas companies, like they are actually incorporated in abroad, like not in Sri Lanka, abroad, incorporated abroad and doing their business in Sri Lanka. That type of companies are known as overseas companies. Right. So basically, these are the companies recognized under Companies Act. Right? Right. So now we are going to incorporate. Suppose maybe a private company or a public company. Right? What else? Right. So these are the documents to be submitted to the registry, right, in order to incorporate. Right. Then one by one we can consider these documents. When we consider the 16A, this one, I think this is the name approval form. This is named as name approval form. Name approval form. That is known as 16A. Now the first step is, in order to incorporate a company under the Companies Act, the first step is selecting a name for the future company. And thereafter, you have to get the approval of the register of companies for the name selected. Then what happens if the name is approved by the register, then name approval number is given. So by this way, 16A, you can get the approval for the selected name, right? Name approval form. Then thereafter, this is the second document, Form 1. It is named as Form 1. Actually, this is the application form. Application. Right? Form 1. Application form. Right. Now, when we consider the application form, right? Initial shareholders of the company must sign this application form with a declaration statement. With a declaration, what is the declaration? To the best of their knowledge, the name of the company is not identical or similar to an existing name of a company. Identical or similar. Name of the company is not identical or similar to an existing name of a company. So that is the statement given by the initial shareholders under application form. Declaration to be given. Understood? Right. Now, what is the meaning of identical? Identical or similar? They have to give a statement stating that the name is not identical or similar to an existing name of a company. That is the statement to be given under Form 1. Under Form 1. Right. Identical means just as same. Right? No difference between two names. Suppose like Bata. That is identical. All words, letters are same. Right? First name and second name, suppose first name and second, identical. Right? Identical. Similar, that is not identical. Similar means like this. Bata, Suppose the first name is Bata and the second name is Bota. Only one letter is changed, but it rhyme, right? Same, right? Bata, Bota, like that. Right? So only thing is now, if the name is identical or similar to an existing name of a company, then it may be deceiving to thinking of the consumer public. Understood? Right? Cheat to the thinking of the consumer public. Therefore, the initial shareholders must give a declaration stating that the name is not identical, right, to the best of their knowledge. Name is not identical or similar to an existing name of a company. Understood? So that is the another requirement you have to fulfill under application form, like declaration to be given. Understood? Yeah? Is it clear? Right. Then we can consider the articles of association. Now, this is the most important document in the company. Articles. Actually, this is the constitution. Constitution of the company. It is equal to constitution. Right? Therefore, actually, we are deeply consider articles of association under particular topic, right? We have taken particular topic, right? Then we can deeply consider the provisions of the articles of association. This is the constitution, right? Constitution. Now, when we consider these documents, right? Name approval form 16A and application form form 1, and we have to submit articles of association of the company, right? Constitution of the company, right? Now, preparing a new constitution or articles of association, it is difficult task, right? It's a hard work, right? Therefore, in order to overcome that, there are three options recognized under the Companies Act. Right? So actually, when we consider the options recognized, right? With regard to articles, we can identify three options here. Right? First option is you can prepare a new article, right? And opportunity is given to the applicant company. If the company wants to prepare new articles, right, then they can prepare new articles and submit it, right? So they can prepare their own articles, right, and it can be submitted to the registrar. That is the difficult work, but that opportunity is given to the applicant company. Right? And the second option is, right, now when we consider the Companies Act, there are several schedules attached to the Companies Act. So in the first schedule, a model set of articles set out. Model is set out in the first schedule. Model set of articles. Understood? Right? Model set of articles set out in the first schedule to the Companies Act. So when you consider these schedules, right, the first schedule, there is a model set. Model is given. Model of the articles given in the first schedule to the Companies Act. Then what happens? You need not to prepare new articles. You can adapt the model set out articles set out in the first schedule to the Companies Act. That is very easy, right? That is the easiest way, right? You need not to worry about preparing a new article. Preparing the article is a very difficult task. So we have to consider all the things, right? Now, when we consider the articles of association, we have to mention the objects, rights and privileges of the shareholders, right? Provisions with regard to management and administration, right? And all other privileges given to the shareholders, directors, like that. Everything you have to consider. That is very difficult task. Therefore, right, in order to overcome that, right, then the second option is introduced under the Companies Act. Therefore, actually, model set is given in the first schedule to the Companies Act. You need not to prepare a new one. You can straight away adopt the model set. Then you need not to submit articles of association to the register of companies. Right? So that is the third option. Sorry, second option. So this is the first one, second one. You can adopt the model set of articles set out in the first schedule to the Companies Act. Right? That is very convenient. Right? And the third option is actually, now suppose if you unable to adopt the model set of articles straight away, then what happens? You can change the model set of articles. You can change it little bit and adapt it. That is another option given. Right? You can change the model set of articles and adapt it as your articles of association. Right? So that is another option recognized. Right? So you can prepare your own set of articles, or you can adopt the model set of articles, or you can change the model set of articles and adapt it. So three options given with regard to articles of association. Right? Understood. Right? Then, when we consider the Form 18, this is the consent of the initial directors to act as the directors of the company. Consent of the directors. Right? First set of directors, right, must give their consent to act as the first set of directors of this company. See what happened actually after incorporation of the company, the person's name in Form 18 automatically be appointed as the first set of directors of the company. Right? So that will happen after incorporation. So first of all, they have to give their consent. Cannot they know it? Adhyakshakaru region can Padakarani cannot be given. So consent to be given under Form 18. And Form 19, this is the consent of the first secretary of the company. First secretary of the company. Right? Like very simple. Right? So these are the documents. Right? 16A, Form 1, Articles of Association, Form 18 and 19 to be submitted to the registrar in order to incorporate a company under the Companies Act. Right? Then what happens? After submitting all the documents with the relevant fee, then what happens? Yes. Yes. Then what happens? Register of companies, right? Register of companies, ROC, right, shall enter the particulars of the company on a register. Enter the particulars on a register. And another very important thing is he shall assign unique number to the applicant company. company number. It is known as company number. Is given to the company. PV number. Now, if it is a private company, you can identify after the name, right? The number is given starting with PV, PV007 like that. That is known as company number. So assign a unique number to the applicant company. So this number is very important one because now you can change the name of the company. Right? So after starting the company, if the shareholders wants to change the name, then actually by passing a resolution, special resolution, they can change the name. But only thing is this company number cannot be changed. It is remain uniform until the winding up of the company. Understood? So number cannot be changed. So this number is given by the register of companies. Right? Unique number. Unique means it is only to this company, applicant company. Right? So unique number given to the applicant company. Then the third document issued by the company, register of companies, that is certificate of incorporation. Right? Registrar shall issue certificate of incorporation to the applicant company. Right? So the registrar shall issue certificate of incorporation to the applicant company. Right now, when we consider the certificate of incorporation, actually this is equal to birth certificate. Birth certificate. Now we have discussed there are two types of persons: natural persons, legal persons. Right? As a natural person, we have a birth certificate. And as a legal person, they have birth certificate. That is known as certificate of incorporation. In our birth certificate, what are the particulars mentioned? Yes, in that certificate, name. Right. So here also name to be mentioned. What is the name of the company? Date of birth. Here, date of incorporation. Right. Instead of birth, incorporation. So that is the birthday of the company. Right. So date of incorporation. Then in our certificate, sex, male or female. Here also they have to mention now under company set there are three types of companies. Basically, three types can be incorporated: limited, unlimited, company limited by guarantee. So certificate of incorporation shall specify whether the company is a limited company, unlimited company, or a company limited by guarantee. Right? So that the type of company to be mentioned in the certificate. Then thereafter, as we discussed, limited company can be divided into two as public and private. Then we have to mention whether this is the private company or not. And we have to mention in the certificate. Right? And another type I told you, type of company, that is offshore company. Then we have to mention whether this is an offshore company. Right. So these are the particulars to be mentioned in the certificate of incorporation. Basically, name, number. Number is given because in our birth certificate, no number. I don't know. Right? Number is given, no, not right. Whatever number, unique number to be mentioned. Name, number, and date of incorporation and the type of the company to be mentioned. So these are the main particulars to be mentioned in the certificate of incorporation. So now what happened after the document received by the register of companies, that he shall enter the particulars of this applicant company on a register, right? And thereafter assign a unique number to the applicant company as the company number. Then what happens? Certificate of incorporation is issued. Right? Then after incorporation of this company, like after incorporation, now the incorporation is completed. After issuing the certificate, then incorporation is completed. But we have to do some other activities after incorporation as well. Right? Now that is after incorporation, within 30 working days, after incorporation, within 30 working days, this company shall give public notice. Public notice. Right? After incorporation, within 30 working days, the company shall give public notice of its incorporation. Right? So public notice to be given. Right? How company can give a public notice? You have to inform it to the public. Right? The company is incorporated. So that notice to be given to the public. How company can give the public notice? Yes? Yes. Publishing notice in 3 daily newspapers in 3 languages, Sinhala, Tamil and English. Right? One notice, 3 daily newspapers in 3 languages. Right? So that notice is published like that. Likewise, then that is the way how the company can give the public notice to the public. Right? Notice to the public. Right? So in this notice, right, company has to mention the name of the company, company number, and the address of the registered office. Address of the registered office of the company. So these are the particulars to be mentioned in the notice. Right. Now what happened? Now I told you, first of all, we have to get the approval for the selected name by name approval form 16. Then thereafter I told, in the application form, form 1, initial shareholders must sign with a declaration, right? That is, to the best of their knowledge, name is not identical or similar to an existing name. Then here what happened? Public notice is given. Right? After incorporation, within 30 working days, public notice to be given to the public. Right? Public notice given to the public. Right? To the world. Right? World for the country at large. Notice is given to country at large. Right? By way of publishing an advertisement in 3 daily newspapers in 3 languages. Then suppose if now after the public notice, within 3 months time, 3 months, right? Another company can complain to the register of companies, right, as to that the name of the company is identical or similar to existing name of the company. Now suppose before this company, another company is registered. So it is, we can name that company as first registered company. First registered company. and this company is registered thereafter. So this is the secondly registered company. Right. So after the second company registered or the incorporated, within 30 working days, they have to give public notice. From that public notice, right, within 3 months, first registered company can make an application to the register of companies stating that the name of the company is identical or similar to our name of the company. Understood? Then what happened? Another filter actually, right? But this can filter. Actually, the company cannot incorporate, right? By a name which is already existing, right? So here what happened? Registrar can give a direction to the second registered company to change its name. And thereafter that company, the second company must change its name within 6 weeks time. So by that way, right, the name can be changed. Right? So reason is give notice to the public if they have any complaints regarding this company, right? Then they can make application to the register of companies regarding that. Right? So that for that purpose, right, if it is newly incorporated company, then within 30 working days of its incorporation, shall give public notice. Right? So that is the another requirement after incorporation. Right. Then what happened? 60 working days after the publications, the proof of the publication to be submitted to the registrar. After publications, within 60 working days, right, proof of the publications to be given to the registrar of companies. Right? They have to show that they have properly given the public notice. Right? According to the company's act. The proof to be submitted to the registrar within 60 working days after the publication. Right? Then thereafter, right, incorporation is complete. All these steps have been taken. Right? Here, registrar. Now what happened if within 3 months time, the first registered company can make an application to registrar. Then if the registrar is also satisfied that the company's name is identical or similar, then registrar may direct the second registered company to change its name. Right? So after such direction, within 6 weeks, second registered company must change its name. If not, what happens? If such direction is given, but the second registered company does not comply with the direction, then what happens? Within 6 weeks' time, the second registered company does not change its name, then what happens? Then actually the company, right, shall be guilty to an offense. Right? According to the Companies Act, not comply with such direction given by the registrar, then company shall be guilty to an offense. Right? On conviction, be liable to pay a fine. Right? So, not comply with the direction given by the registrar of companies, then it is treated as an offense. Right? It is treated as an offense. Then company be liable to pay a fine not exceeding 200,000 rupees. Right? But not exceeding 200,000 rupees. Right? On conviction, company be liable to pay a fine not exceeding 200,000 rupees. Not exceeding. Yeah. Not exceeding. So that is the maximum amount, 200,000. But court can impose only 10,000 rupees, not exceeding 200. Right? So that is the maximum. Court can impose 250. Maximum is 200. Right? So below 200, any amount can be imposed. Right? Even 10,000, 1,000 also permitted. Right? So okay, within that range, not exceeding 200,000 rupees. So in the first instance, actually 10,000 rupees, 5,000 rupees may be charged as the fine. Right. So that is not comply with the direction given by the registrar. Right. Okay. Now, then what happened? Yes. Then publications will be submitted within 60 working days. Right. So these are steps to be followed in order to incorporate a company under the Companies Act. Right. So first, we have to consider about the 5 documents: 16A, application form, then articles of association, form 18 and form 19. Right? These are the 5 documents. Then after submitting the documents, registrar of company issue a certificate of incorporation. That is the birth certificate of the company. Right? So after incorporation, within 30 working days, public notice to be given by the company. And after the public notice, within 60 working days, the proof of the publications to be submitted to the register. That's all. Right? So these are the steps. Then thereafter, very important document is birth certificate of the company, certificate of incorporation. Right? Now, registrar shall issue certificate of incorporation to the applicant company. Right? We have to consider the legal effect of certificate of incorporation. Right? Actually, what is the legal effect of certificate of incorporation? When we consider the legal effect, right? Actually, this certificate of incorporation is treated as conclusive evidence. Conclusive evidence or we can say irrebuttable evidence. Irrebuttable evidence. Conclusive evidence of or irrebuttable evidence of two things. Two things. This is the most important part. Legal effect of the certificate of incorporation. Irrebuttable. Conclusive. Irrebuttable means you cannot disprove. Understood? You cannot disprove. Right? Irrebuttable. When we consider the presumptions, there are 2 types of presumptions. One is known as rebuttable presumptions, and the second type is irrebuttable presumptions. Right? Irrebuttable means you cannot, by giving evidence, you cannot disprove or change the presumption or the evidence. Like here also evidence. Right? That is known as irrebuttable. You cannot change. Now, when we consider the presumptions, actually in our evidence ordinance, there's a section 112 of the evidence ordinance. It is mentioned about the rebuttable presumption. Rebuttable presumption is now here mentioned husband and wife, right? And suppose their marriage, husband and wife means they have a valid marriage, right? They have valid marriage. Therefore, we name them as husband and wife. Valid marriage. That is the relationship between the husband and wife. Then what happened on this day? Their marriage is dissolved, right? So after dissolution of their marriage, right, they divorced on this day, right? After dissolution of their marriage, within 280 days, 280 days, right? Within 280 days, if a child was born to this lady, then law presumes father of this child as this person, husband. That is the presumption, right? During this period, if the child is born, right, then who is the father? His husband is the father of this child. That is the presumption, right? So this is known as presumption of legitimacy. Presumption of legitimacy. Legitimate child. Legitimate child means child has born as a result of valid marriage. Therefore, legitimate. If there is no valid marriage between parents, then the child is named as illegitimate. Illegitimate. Right? So here, presumption of legitimacy. Right? So this is legitimate child. Right? So now, however, this is a rebuttable presumption. Rebuttable means now if the husband opposed to this presumption, is not agree with this presumption, and he argued, no, I am not the father of this child. Then actually, by giving evidence, if he is able to satisfy the court, then he can disprove the presumption. Right? He can change the presumption. Then we call, he can rebut the presumption. Rebut the presumption. Right? Able to rebut. Right? Disprove by giving evidence. Right? So what are the evidence can be laid in order to rebut the presumption? If the husband says, no, I am not the father, then how he can prove it? How he can satisfy the court by evidence? Yes. Good. The DNA test, DNA test. You can ask for DNA test. By that evidence, actually, he can prove that he is not who is the biological. He can prove that he is not the biological father of his child. Right? That is the way. One method, right? Widely, it is adapted nowadays, right? So that is the way. Understood. So by giving evidence, only thing, if it is a rebuttable means by giving evidence, you can change the presumption. Change. So disprove the presumption. But here, irrebuttable. This is irrebuttable evidence of two things. It means by giving evidence, right, nobody can change it. Nobody can change or disprove. Understood? So that is the meaning of irrebuttable. Irrebuttable. Understood? Right. What are the irrebuttable or conclusive evidence? Right? After issuing the certificate, the first thing is company has taken all necessary steps in order to incorporate it under the company's act. Understood? So all these steps are taken by the company. All these steps are taken. Have been taken. All the steps have been taken. Right? Now suppose Now we have discussed what are the steps to be taken. Due to negligence or otherwise, particular step is not taken. Right? Even though that step is not taken, incorporation, right? Nobody can challenge, right? Nobody can challenge that the incorporation is invalid. Right? So even though such step is not taken, it does not invalidate the incorporation. Understood? So that is known as irrebuttable evidence. By giving evidence, right, you can be satisfied with both, right? This particular step is not taken, but actually, if the certificate is issued, then the conclusive evidence is right. Company has taken all necessary steps. Even though a particular step is not taken, it does not invalidate the incorporation. Understood, right? So that is the first conclusive evidence which is created by this certificate of incorporation, right? And the second one means second conclusive evidence is the company came to an existence on the date which is mentioned in the certificate, right? Company came to an existence on the date mentioned on the certificate and not from any other date. Right? Now we have to, as our birth certificate, we have date of birth in our birth certificate. In certificate of incorporation, uh, they have to mention the date of incorporation. Date of incorporation. Right. Then what happened? Once the certificate is issued, company came to an existence. Existence can have ආරම්භය පැවැත්ම ආරම්භය කවදද වුනේ on the date which is mentioned on the certificate of incorporation. දා වුණා විදියට අපි අර එදා ඉපදුනා විදියට කල්පනා වගේ කම්පැනි එකේ පැවැත්ම ඇති වුනේ කම්පැනි පැවැත්ම ඇති වුනේ අන්නේ සමාන කරලා තියෙන දිවි කියන එක තමයි මෙහි කියන්නේ. Understood? Right. So that is the irrebuttable evidence. Right. Nobody can challenge it. Right? Because now, in a particular case, what happened? The company is incorporated on, actually it is incorporated, actual date is, suppose 5th of January 2020. Actually it is incorporated on 5th of January. Right? That is the actual date. But what happened erroneously, the date is mentioned in the certificate as 3rd of January 2020. This is not correct. But erroneously, right? Erroneously, it is mentioned on the certificate. The date of incorporation as 3rd of January 2020. Right. Now, actually, what happened in this case, on this date, company has issued shares to the public. Company issued shares to the public. Then what happened? A person, he applied for the shares. Now suppose A, this person applied for the shares. Right? Then thereafter, company allotted shares to this person. Right? Then allotted and requested money. Then what happened? This person came to know about this mistake. Because the certificate is wrong date mentioned as the date of incorporation. Therefore, he relied on that mistake. He argued on 3rd of January, actually this company is not in existence. Right? Right? It came to an existence on 5th of January. Therefore, on 3rd of January, this company cannot issue shares. So there is no such company. Right? So this is erroneously mentioned. Therefore, actually, there is no such company on 3rd of January. Right? On that argument, he refused to pay for the shares. Then what happened? Company filed an action against this person, right, in order to recover money. Then the court has to decide whose argument is correct. Right. So what happened? Yes, court held this is conclusive evidence. Right? Company came to an existence on the date which is stated on the certificate of incorporation. Nobody can challenge it. Reality may be different, but this is conclusive evidence. Therefore, court held on this date, this company can issue shares. Issue shares, therefore, this person has to pay for the share. Understood? So that is the decision given in this case. Only thing is conclusive evidence. Nobody can challenge by giving evidence, right? Challenge it. And nobody can disprove these irrebuttable evidence, right? That is the meaning of irrebuttable or conclusive evidence, right? So the company came to an existence on the date it is mentioned on the certificate. It may be wrong, doesn't matter. Once the certificate is issued, it becomes conclusive evidence. Nobody can challenge it. Understood? So that is the meaning. Right. So what happened? Certificate of incorporation is issued. Then this certificate creates two conclusive evidence. That is, company has taken all necessary steps in order to incorporate. Therefore, even particular step is not taken. It does not invalidate the incorporation, right? And company came to an existence on the date which is mentioned on the certificate, right? So that is the second conclusive evidence, right? Is it clear? Right. So that is with regard to the certificate of incorporation. Right. But then we can move on to another concept. Right? Uh, now, suppose there are two persons, uh, Arjuna, Arjuna and Panda. So we can identify these two as natural persons, Arjuna and Panda. Right? They have incorporated a company by name EB Private Limited. Right? Now, what happened after incorporation? Right? After incorporation, Arjuna is a one person, Panda is another person, and this company is treated as the legal person. Legal person, the company is another person. So after incorporation, how many persons? Three persons. Two natural, right? And one legal. Altogether, three persons. Right? Right. Now what happened? This company has borrowed 100,000 rupees, 100,000 rupees from a bank. Right? Company has taken a loan from a bank. Right. Then what happened? Company has taken a loan from a bank. Then what happened? Company defaults in payments. According to the bank statements, like company has to pay 80,000 rupees. So this is the outstanding amount of the loan. Right? So now suppose bank wants to recover the outstanding amount of the loan. Right? Then the issue is, right, can bank, this person or creditor, right, bank or the creditor, can creditor file an action against, after incorporation, suppose Arjuna and Banda, they became the shareholders of the company. Shareholders and, sorry, before that, we can identify three categories. We can identify three categories. Now I told you A and B incorporate the company. They are the founders, right, of the company. So they are creating the company, right? Creating the company. They are the creators, right? Creators. You can say A and B, right? A and B, they are the creators, right? Then after incorporation, suppose A and B, Arjuna and Banda became the shareholders of the company. Shareholders. And they are the directors of this company. Directors. So we can identify three categories: creators, directors, and shareholders. Right? Creators are known as promoters. Promoters. Promoter. Right? Promoter is a person who is taking necessary steps in order to incorporate a company under the Companies Act. Promoters. Right? Shareholders. Who are the shareholders? They are the, yes, they are the owners of the company. Very good. Owners. Directors, they are what they are doing in the company. They are managing the company. Understood? They are managing the company. Managing the company. And so we can identify three parties: promoters, managers or directors, and the shareholders. Right? Right. Now what happened? The amount to be paid to this creditor. Right. Now the creditor wants to recover this money. Right. Now the issue is whether creditor can file an action against the directors of this company. Means, can creditor file an action against Arjuna or Arjuna and Banda or the promoters or the owners? They are the owners. A and B, they are the owners. Can creditor bring an action against owners in order to recover the money? How they can recover the money? Right? To whom against case to be filed in order to recover the money? Yes, there are several parties, right? Arjuna Banda, right, and the company, AG Private Limited, the legal person, right? So, how creditor can recover the money? To whom against that case to be filed? Yes. Can they bring an action against Arjuna? Creditors? No. Banda? No. Against whom? creditor must file an action against AB privately limited because it's a legal person. Understood? Right. So this is the concept. Right. After incorporation, company is treated as a separate person from those who create it, own it, or manage it. Understood? Three columns: creators, uh, owners, like shareholders, and the management, who are managing the company, directors. Therefore, for the activities of the company itself responsible. Not the shareholders, directors, or the promoters are responsible. Understood? Right. So that is the concept. This concept is known as separate legal personality concept. Separate legal personality concept. Or it is known as another name, veil of incorporation. Veil. Veil of incorporation. Veil of incorporation. Veil එක මනමාලි දාන veil එක ඒක තමයි veil එක. veil. අසාද වදිනකොට දාන්න. වදින කලින් තමයි veil එක දාලා ඉන්නේ. දැන් පස්සේ veil එක තියනකොට මොකද තියෙන්නේ trust එක. veil එක තියනකොට හරියට ආයේ මූණ පේන්නේ නැහැ. දැන්ලා ඉවෙනවා veil එක අයින් කරනවා. ඒ වගේ තමයි veil එකක් වැටෙනවා දැන්. Right? There is a veil after incorporation. There is a veil separating the company from Arjun and partner. Therefore, actually, what happened? Third party creditor, as the third party creditor, cannot see who are behind the veil. Right? He can see only the company. Therefore, in order to recover money, creditor must bring an action against company. That is the concept. Because of they cannot see, like a wall, we cannot see beyond the wall. Right? Therefore, we can see only this one, then we have to bring an action against that part. Right? Only to this company. Understood? So this is known as veil of incorporation, or separate legal person. Right? So the concept is after incorporation, company is treated as a separate person, right? Separate person from those who create, own it, or manage it. Therefore, for the activities of the company itself responsible. Responsible. Right. Now I have uploaded note to your LMS, right? You can go through that. All the particulars are mentioned there, right? So when we consider that note, basically two types of persons recognized, right? Natural and legal, right? And thereafter, what are the name types can be incorporated under the Companies Act is mentioned. Limited company, unlimited and company limited by Galle. Then as the procedure, we have mentioned about the 5 documents, right? 16A, application form, articles of association, and Form 18 and Form 19. Then thereafter, the certificate of incorporation is issued to the applicant company. Then within 30 working days, public notice to be given. Then after publications, within 60 working days, the proof of the publication to be submitted. Right? Then the certificate, as we discussed, when we consider the content of the certificate, name of the company, number, date of incorporation, where the company is a limited company, unlimited or company limited by guarantee, where the company is a private company. We have to mention that, right? Private. And where the company is an offshore company. Now, offshore company, when we consider the offshore company, now, offshore company means offshore company. Right? Show can mean a viral, viral තමයි off. එවනත් අපි කියන viral එහා අක්කරල සමාන කියලා offshore. Right? Offshore company. Offshore company, right? Now, here also we have mentioned the word incorporation. Right? Incorporation and registration. Right? There are two different words, incorporation and one is incorporation. And Another term that is known as registration. Right? Now, when we consider the offshore company, it is incorporated. Right? It is incorporated in Sri Lanka, or abroad. Two options. Incorporated in here or another country. Right? Doing and registered under the Companies Act as an offshore company. That is the definition here. Incorporated in Sri Lanka or abroad, registered as an offshore company under the Companies Act. That company is treated as offshore company. What is the main feature of the offshore company? They cannot do any business activities in Sri Lanka. They have to do all their business activities abroad, not in Sri Lanka. That is the main thing. Understood? So it may be incorporated in Sri Lanka or abroad. That's why we cannot be included to the that category. Understood? So, but in the certificate, we have to mention whether it is a offshore company because it may be incorporated in Sri Lanka, right? Incorporated and registered as an offshore company under the Companies Act, right? It means now suppose incorporated abroad and registered as an offshore company under the Companies Act, right? In order to get some tax privileges or reasons, right? They can ask to register under the Companies Act. It may be incorporated abroad or here also in Sri Lanka can be incorporated and registered as an offshore company. Only thing means they cannot do any business activities in Sri Lanka. Right? So that type of companies are known as offshore company. Another type is overseas company. Overseas company means actually it is incorporated overseas, incorporated abroad, doing their business in Sri Lanka. That is the overseas company. Right? They have a established place of business in Sri Lanka. Right? Here they are doing business, right? But incorporated completely, they are incorporated abroad. So that is the offshore company and overseas company. So in these articles, we have to mention whether it is offshore company, private company, limited company, unlimited company, or company limited by company. Right? Then thereafter, the legal effect of the certificate of incorporation is mentioned here. All the steps are taken, conclusive evidence or irrebuttable evidence, and the company came to an existence on the date which is stated on the certificate. It is also mentioned here. And the case is given usually Cotton Wheels versus Levi's. You can go through that. It is similar to what I explained, right? The date of incorporation erroneously mentioned, right? So you can go through that. The case actually held that the date mentioned in the certificate to be treated as the date of incorporation, right? It is conclusive evidence. Then the separate legal personality or veil of incorporation. That concept is here mentioned. Now, as we discussed, after incorporation, the company is treated as a separate person, those who create it, right? So this concept is known as separate legal personality. And for the activities of the company itself liable. The company can engage into any transaction with the third party. Like they can own property, be sued and sue against the others, right? All the rights as the human being, this company, legal person, will receive after incorporation. It is treated as a legal person. Therefore, for the activities of the company itself responsible. Right? Company itself responsible. This concept is known as veil of incorporation, or separate legal personnel. Right? Now there is a case mentioned here, Solomon versus Solomon Company Limited. I think it is a well-known case, right? Solomon versus Solomon Company Limited. Right? So actually this concept, separate legal personality concept, first time in the legal history, right, disclosed in this case, Solomon versus Solomon Company Limited. Solomon Solomon versus Solomon Company Limited. This is the case, right? Solomon, Solomon, no Solomon, whatever, right? Right. Actually, now when we consider the facts of this case, Solomon is a boot manufacturer. Right? He has a proprietor business, right? That is manufacturing boots, right? And thereafter, after some time, then he incorporated a company by name Solomon Company Limited. That is the name of the company. Mr. Solomon incorporated a company by name Solomon Company Limited. Right? Then what happened? This company issued debentures. Right? Debentures issued by the company, and all the debentures were secured on the assets of the company by giving security on the assets of the company. Company issued debentures. Debentures. All the debentures were purchased by Mr. Salman. Right. Debentures are secured on the assets, and all the debentures were purchased by Mr. Salman. Right. Then what happened? Further, this company has borrowed a loan from a third party creditor. Third party creditor. But what happened here, the creditors did not take any security for the loan given. This loan is not secured on assets. Right? Like here, debentures, right? Assets, mortgage, right? And issue the debentures. Right? Here, no security given for the loan given by the creditors. No security. Right? Now what happened? After a short period of business, this company suffered heavy loss and liquidity. Right? Now in the liquidation process, actually, what will happen? Company has to collect all its assets, collect the assets, and realize them, right? Sell them now. And out of the proceed, out of the money, right? they have to settle the creditors. Creditors, then thereafter, after meeting the winding up expenses, if any amount remains, then it will be distributed among the shareholders. The remaining amount is known as surplus assets. After settling the creditors, if any amount remains, right, if any balance remains, then that is known as surplus assets distributed among the shareholders. That is the process, right, procedure, the winding up. Right. Now what happened? Actually here, there is no sufficient assets to settle debenture holders, and there are main two types of creditors in this company: debenture holders and the third party creditors. But the company has no sufficient assets to pay off debenture holders and third party creditors. Right. So that is the issue, main issue, right, arose in this case. Right. Now what happened? Because of that reason, no sufficient assets. Solomon said, Mr. Solomon, he said he must be given the preference, priority to be given to him because his loan or debentures were secured on the assets of the company. Therefore, he must be given the preference while settling the creditors. Right. He said, first, my loan to be paid because my debentures are secured on the asset. They have priority to be given to me. That is the Mr. Solomon's argument, right? But the third party creditor, right, they didn't take any security, but they argued on a legal basis, legal rule, legal concept. That is, they said, right, there is a legal concept. Legal concept, it says, right, there's a legal concept as to no one can owe money to himself. Oh, no one can owe money to himself. Mata manai veena pula. Mata manai veena pula. Adane mamma degiwa, ivanna pula gattikko. No one can owe money to himself. Right. So here the argument is Solomon is the main shareholder, right? And he is the creator and the director. Therefore, in fact, Solomon and the Solomon Company Limited, right, one and same person. One and same person. There are no two persons. One and same person. Therefore, because of this concept, no one can owe money to himself, right? Therefore, we must be given the preference. Right? That is the argument made on behalf of the third party creditors. The argument is Solomon and the Solomon Company Limited is one and same person. Understand? Because actually he is the creator. He is the creator, he is the main shareholder, he manages the company, right? It will be up to him. Therefore, one and same person, company and this person, right? Therefore, we must be given the preference. That is the argument made on behalf of the third party creditors. Then what happened? They went to court in order to get a declaration regarding which party is correct, right? Then what happened? So that is the first time in the legal history court held, yes, this concept is correct, but court held after incorporation, right? After incorporation of the company is treated as a separate person. Therefore, Solomon is a one person and the company is another person. Therefore, Solomon can give a loan to the company, even though he is a main shareholder, director, whatever, right? It doesn't matter. Another person is created. Right? Therefore, after incorporation, there are two persons. Therefore, Solomon can give a loan to the company. Right? So, if the loan, Solomon's loan is secured on the assets, then he must be given. So that is the decision given in this case. First time in the legal history, this concept, separate legal personality is recognized in this case. Understood? So that is the case. Right. So actually, according to this case, right, it has decided several concepts. One is after incorporation, company is treated as a separate person, right? And shareholder can give a loan to the company. Right? Even though he is a shareholder or a director, can give a loan to the company. And the third concept is secured loans, right? Secured creditors, you can say secured creditors must be given the preference over the unsecured creditors. Now here also, the purchase the debentures, then Solomon can be treated as a credit, right? Secured credit must be given preference over the unsecured credit. We can සුරක්කුමක් සහිත ණය දීපු අය හරි ප්‍රමුඛත්වයේ ගන්නවා සුරක්කුමක් නැති අය කරන්නේ. Right, so that is the concept recognized in this case. Right, so Solomon versus Solomon company. Then actually hereafter all the judgment, there are several series of judgments we can identify. Right, several cases, case laws recognize the concept of separate legal person concept. Right. And another case I have mentioned here, Macura versus Northern Assurance. Right, another case mentioned, Macura, Northern Assurance Company Limited. In this case, actually, Mr. Macura is the person, right? Mr. Macura, he is the owner of a timber estate. Timber estate, right? Owner of a timber estate, and he had a fire insurance policy, right? He had a fire insurance policy to this land, timber estate, right? Then what happened? He incorporated a company, right? Macura incorporated a company and became the main shareholder of the company. Right? Incorporate the company, became the main shareholder of the company, and the ownership of the property in the state is transferred to the company's name. Right? Property transferred to the company's name. Even though the property transfer, ownership transferred to the company's name, the fire insurance policy is not changed. He continues the fire insurance policy which is in his own name. That's the wrong thing he has done. Right? Then what happened? One day, the timber estate caught fire and destroyed. Then Mr. Macura claimed the insurance benefits. Right? But insurance company said Mr. Macura cannot ask for the insurance benefits. Reason is timber estate is owned by the company. Right? He is the main shareholder. Therefore, the shareholder of the company has no insurable interest over the property of the company, because company is a one-person shareholder, so the owners are treated as another party, right? Therefore, there are two separate persons, right? Therefore, Mr. Macura has no insurable interest over the property of the company. Again, separate legal personality concept recognized. Actually, what happened, Mr. Macura filed an action against the insurance company in order to recover the damages, but the court said, yes, Mr. Macura has no insurable interest because he is a one person, company is another person. Right? Company can insure his properties in his own name, company's name, but shareholder has no right to insure the properties of the company. Same concept recognized in here also. Right? So Macura versus Northern Assurance company. Right. So separate legal personality concept is recognized in these cases. Understood? Any questions?
And considering previous scenario, if directors use personal guarantee to creditors, personal guarantee, as a director, can you give personal guarantee to company?
This one?
Yeah.
Personal guarantee. Now, what is the meaning of guarantee? Guarantee. The legality of the guarantor, that is like this. Now, suppose he has given one value can guarantee, then A has given a guarantee to B, then B takes a loan from C, right? A is a guarantor, and B is the debtor, and C is the creditor. That is the relationship. Now, guarantee means, now suppose debtor defaults in payment. Then what happens? Creditor, right? Creditor must file an action against debtor in order to, now suppose the defaulted amount is 100,000 rupees. Right? Creditor must bring an action against the debtor. So this is the first step. Right? Creditor must bring an action against the debtor in order to recover 100,000 rupees. Right? Then suppose after filing an action, creditor able to recover only 8,000 rupees from the debtor. Then the balance amount is 20,000 rupees, unable to recover from the principal debtor. Right? So in order to recover that balance amount, 20,000 rupees, creditor can bring an action against the guarantor. So that is the concept of guarantee. Understood? So there are two steps. First, creditor must file an action against the principal debtor. If he is unable to recover the amount fully, then in order to recover the balance amount, he can bring an action against the guarantor. So it means, right, if creditor able to recover 100,000 rupees from the principal debtor, can he bring an action against the guarantor? He can't bring an action. Only guarantee is responsible to pay balance amount. Understood? So if the total amount is recovered from the creditor, principal debtor, then guarantee is not responsible. Understood? So that is the meaning of guarantee. So I don't know how this apply with this. Right? So that is the concept. So there is a responsibility on the part of the guarantor. It is that total amount, outstanding amount, unable to recover from the principal debtor. Right? That is the meaning of guarantee.
In real scenario, most of the suppliers they used to file against creators. Most of the cases, they are file the case against the company directors, not the company.
Then they have given the guarantee. Guarantee and indemnity bond, there are two different. If it is an indemnity bond, I don't know, we have to clearly go through the agreement. If it is a guarantee, then like this. Indemnity bond means indemnity bond. Indemnify. Now, insurance is a indemnified bond. Right? If it is an indemnified bond, then actually C need not to bring an action against B, principal debtor. Straight away, C can bring an action against the person who has given the indemnity. Right? Indemnify, who agreed to indemnify the loan. Understood? So that is different. Right? Guarantee and indemnity. Right? Guarantee like this, right? Indemnify. Then actually C need not to bring an action against B, even though we seek and recover the full amount from the need not to fight. Straight away, he can bring an action against A. So, depend on the agreement given by the parties, right? Indian people and government, right? Two different concepts, right? Right, what else? So, anyone can give guarantee or Indian. Fine.
We have to memorize all these cases, or is it?
You need not to memorize these, right? Only the facts to be remembered, right? If it, there are maximum five cases we are discussing under corporate law. It is not like business law. Under business law, corporate contract law, there are several cases, right? Not like here, only five, 6 cases we are discussing under the corporate law. Right? If you are able to keep remember the name of the case, that is it is convenient, right? When you are answering to the questions, it's convenient. Without going for further verifying the facts, straight away you can mention the name and answer it properly, right? So, like maximum 5 cases we are discussing under the corporate. So basically now we are discussing about the other corporate law, the provisions contained in the Companies Act. So sections are important, but actually we are not concerned about sections or the facts to be remembered. That's the big problem. Section one material that are sections are like maybe right. What else? Right. Then now because of this concept, veil of incorporation, third party cannot bring an action against the cannot bring an action against the shareholders, directors, or employees of the company. Right? Right. Now, because of this concept, veil of incorporation. Right? In I told you after incorporation, there is a veil separating the company, right, from those persons, shareholders and directors. Right? There is a veil. Right? However, because of some reasons, right, court has power to lift the veil, remove the veil. Court can remove the veil. If the veil is removed or lifted, then what happens? Third party, now is the third party. This third party, if the veil is removed, right, lifted, then what happens? Third party can see the shareholders, directors, promoters. Understood? Third party can see. Right. Understood? If the third party can see shareholders, then actually third party can bring an action against the shareholders. Right? So removal of or lifting of veil of incorporation. Lifting of veil of incorporation. It means making these persons responsible for the activities of the company. Understood? Right. So we are going to discuss about what are the instances that the board can remove the veil of incorporation. Right. Another thing. Now, as a rule, we discuss separate legal personality. That is the rule. So these are the exceptions. Exceptions to the rule. There are several exceptions recognized. Right? So under exceptions, right? Shareholders, directors, or even employees of the company are responsible for the activities of the company. Right? So generally, as a rule, for the activities of the company itself is responsible. But under exceptions, shareholders, directors, or these persons are responsible for the activities of the company. So actually, the lifting of veil of incorporation means making shareholders, directors, promoters, employees of the company responsible for the activities of the company. Very simple, right? Okay. Now, when we consider the lifting of veil of incorporation, we can lift the veil of incorporation by two methods. One is according to the provisions contained in the Companies Act, right? According to the sections mentioned in the Companies Act, we can lift the veil of incorporation. The second method is according to the case law principles, case laws. We can lift the veil of incorporation. Right? There are many case laws there. Right? So maximum 5 cases. Right? So according to some case laws principles, we can lift the veil of incorporation. Right. Now, when we consider the Companies Act, right? There are several sections mentioned, right? So now, according to Companies Act, now suppose like this, there is a company A, B, C Private Limited or ABC Limited. It's a public company, like ABC Limited. This company issue a check. Right? In favor of B, another person. So X, you can say X. Right. So on behalf of the company, two directors sign the check. Suppose A and B, right, sign the check. But actually, when we consider the check, right, in this check, the company's name is not properly mentioned. Right? The name of the company is not properly mentioned. It is mentioned on the check wrongfully as AB Limited. The correct name is ABC Limited. But this document or the instrument says the company's name as AB Limited. There is no such company. AB Limited. The so-called company. Right? Right. Now suppose if the real company ABC Limited refused to admit the responsibility, right, which may be created on this document, then who is responsible? Yes. person who signed the check. A and B. They are personally responsible if the correct. So the actual company refused to admit this responsibility. Understood. So that will happen because of the section 12 of the Companies Act. Companies Act section 12 says, like, the name of the company must properly and correctly mention on all the documents and instruments which are creating a responsibility. Right? If the name is erroneously mentioned, wrongly mentioned on the document, and if the company refuses to admit that responsibility, the person who signed the document is personally responsible. So for the activities of the company, these persons personally responsible. Reviewing of Veil of Incorporation or lifting of Veil of Incorporation. Understood? So for the activities of the company, like directors or the shareholders are personally responsible because of section 2. Understood? Right. Then there's another one. Another one is, I think it is known to you. Now, according to the Companies Act, mother company or holding company has to prepare group accounts for the entire group. Now, in this company, this is the mother company, and there are 3 subsidiaries. According to the Companies Act, mother company, holding company must prepare group accounts for the entire group. So, how that mother company can prepare group accounts for the entire group? Because now, when we consider from the point of view of the law, right, mother company is a one person, and subsidiary S1 is another person, another legal person, subsidiary one, another company. S2 is another person, S3 is another person, mother company is another person. So how company, mother company can prepare group accounts. Right? So for the accounting purpose, we have to remove the veil of incorporation in order to prepare the group accounts for the entire. Right? So here also what happened, we remove the veil of incorporation, the concept of separate legal personality concept, remove that, and treat each subsidiary as an economical unit of the mother company. Right? That is only for the preparing accounts on behalf of the group, entire group. Understood? Otherwise, we cannot prepare it because S1 is a one person, separate person. We cannot make accounts of the S1. S2 is another person, but we have to ignore that separate legal personality in order to prepare the group accounts. Understood? So that again, another situation that we can exclude the separate legal personality. Right? Another one recognized, another one that is according to the Companies Act 219, section 219, it says, now there is a director of the company. Suppose this is the company and there is a director. Right? 219, it says, right? Right, whatever, right? Company and the director. Right? Now here what happened? Director came to know that the company unable to pay its debts in its ordinary course of business. Right? He came to know about it. Then what happened? Companies Act says he must immediately call board meeting. Right? He must immediately call board meetings. Now when we consider the meetings in a company, There are two types of meetings. Later on, I will discuss. Right? Meetings, another topic, separate topic. Right? So there are two types of meetings. One is directors meeting. Right? Another type is known as general meeting. General meeting means shareholders meeting. Shareholders meeting. So shareholders meeting we can further classify it as AGM, EGM. EGM. Right? AGM means annual general meeting. Once in each calendar year, right? A meeting to be called in every company that is known as AGM. EGM means, right? All the meetings other than AGM, right? EGM, extraordinary general meeting. These are shareholders meeting. Right? So here, another type is directors meeting. Now here, Companies Act says where the director came to know that the company unable to pay its debts in its ordinary course of business, then he immediately called directors meeting. Right? Directors meeting. If he fails to do so, then what happens as a result of the company continues its business and liquidated, then this director is personally responsible to the creditors. This is the duty of a director. Right? This is a duty cast on a director. If he came to know that the unable to pay debts day-to-day business, immediately he must call. Only thing is he has to call the meeting. That is the responsibility. Call the meeting. Otherwise, he is personally responsible for the creditors if the company is liquidated. Right? Understood. So that is another one. So here, what happened? Director personally responsible for the creditors. He is responsible to compensate the creditors personally because of breach of his duty. Understood? Personally responsible for the activities of the company. This person is personally responsible. Understood? Right. So there is another section mentioned in the Companies Act. So these are the provisions contained in the Companies Act for the exceptions to the rule of separate legal person. Very simple. Right. So the first one it says the name of the company. If the name is not properly mentioned, then the person who signed the document is responsible. And the second one is a concept actually. Right? Here actually in order to prepare the group accounts, we have to remove the date of incorporation of the subsidiaries. Right? And the third one is this is a duty cast on a director. Right? If he came to know that the company unable to pay the debts, then he has to call a meeting, directors meeting, right? General meeting, directors meeting. Yeah. That's why I mentioned here. Directors meeting. He has to call directors meeting. Otherwise, he is personally responsible to the creditors if the company became liquidated. Right. So there is another duty, another exception to the rule of separate legal personnel. Right. So that's all. Right. So that is about the according to the provisions contained in the Companies Act. Right. So there are three provisions we have mentioned. Then we can go on to case law principles. I told you the bail of incorporation may be lifted by case law principles. And here we have to consider two case laws, two cases, right? Uh, in first case, what happened? Two persons, employer and employee, A and B, employer and employee, right? Employer and worker. They had an agreement, service agreement. according to this agreement, this person, employee, cannot engage into contract with the customers of the employer after his services were terminated. Restriction or restrictive clause in the agreement. Restrictive clause. There is a restriction. What is the restriction? If your services were terminated, then thereafter you cannot engage into contract with my customers. Right? Because in order to protect the business, that type of clauses may be included to the agreement. Right? So here also that clause is mentioned in the agreement. Right? After your services were terminated due to any reason, you cannot engage into contract with my customers. We have to protect our customer base. Right? So there's an agreement, and according to the agreement, employee agreed to not to engage into any contract with the customers after his services are terminated. Then actually what happened? This person very right. This sort of person, right? Then actually what happened? He resigned from the employer. After some time, he resigned from the employer, and he incorporated a company. Company is incorporated. Then what happened? Through the company, he engaged into the right. Through the company, he engaged into contract with the customers of the employer. Because his name is not now highlighted. Through the company, he engaged into contract with the customers of the employer. Actually, now what happened? According to law, he cannot do that. This is illegal activity. But what happened? He used this separate legal personality concept in order to do an illegal activity. Then what happened? Actually, the employer, right? He came to know about this incident, right? Through the company, this person engaged into contract with the customers. Then what happened? Employer filed an action against the company, right? Then what happened? Court lift the veil of incorporation. Then identify who is the owner. Who is the owner? This person. Therefore, right, court made an order against the employee not to engage in the contract with the customer. And so here actually we call this type of companies puppet company. රූකඩයක් කියන්නේ. රූකඩවලත් එහෙම ඇතුලේ ඉඳන් නරකට මිනිහෙක් ඇතුලේ ගිහින් තියෙන්නේ නේ. Puppet company or sham company. Right? If it is a puppet company, then actually court can lift the veil of incorporation. The one method that court, there's a case given here, right? Then actually court can lift the veil of incorporation in order to identify the real situation, right? So nobody can do any illegal activity by using this concept, separate legal person. Right? If they are doing illegal activity, actually court can lift the veil of incorporation and right, take the responsibility. Right. So that is the one case. Another case, another one, that is between two countries. I think two countries are Germany and England. Right? There are two countries. Suppose this is one country and another country. Germany and England. Germany and England. Right. What happened in this case? In England, a company was incorporated. Company was incorporated. Right? All the shareholders of this company are citizens of Germany. So shareholders, all the shareholders are citizens of Germany. Right? Then what happened? This company has given a loan to a person called X. Suppose X. X, he is a citizen of England. Citizen of England. this country. Right? Then what happened? This person defaulted in payments. Then this company filed an action against X in order to recover the money. And file an action. Then what happened? Meantime, war started between Germany and England. I think what happened after the war started, right? Then court has to decide. Now, according to all the facts, actually, this person has taken loan from the company and he is defaulted. But only thing is, right? Now, court can give an order in favor of this company. Right? So, in order to decide that, after the war started, then what happened? Court leaves the way of incorporation. Then identify all the shareholders of this company, right? Right? All the shareholders are citizens of Germany. Now, after the war started, citizens of each country they became enemies of each other. Right? So now here court identify owners are enemies of this country. England. Right? Can court give an order in favor of the enemies? Can't. Understood? Because of the national emergency, right? So give an order in favor of enemies means they will receive money. They will receive money. Right? Then they can do the work properly, more than before. So money supporting financing the enemies, right? Giving loan, giving money to the enemies. Therefore, because of the national emergency, court can, yes, you need not to pay for the company. Right? So lift the veil and identify the situation. Thereafter, court has given this person, this citizen, X, need not to pay money to the company. Because according to the terms of war, contracting links, right? So financing the enemies, like it is prohibited by law. Right? Therefore, court held he need not to pay for the company. Right? So another case, right? Court lift the veil in order to identify two cases we have mentioned. Understood? Is it clear? Right. So by two methods we can lift the veil of incorporation. So this is the first topic. Now, when we consider the note, actually lifting of veil, these two methods are deeply considered, right? According to the Companies Act Section 2A, 152 to 90. 290. There are three sections mentioned there. And yes, then as compared to it says lifting of veil by case law principle. Then if the company is a puppet company or sham company, the court can reach, and because of the national emergency, right, the court can lift the veil of incorporation. That case is Daimler versus Continental Tire Company. And you can go through the same facts are same as mentioned. Right. That's all. Yes. Any questions? Not your question. Very good. අවුලන්නේ අතර මේ විශේෂ ලේසි පොඩි පොඩි වගේ අපි ඒක කොපි එක අරගෙන අපි බලන්නේ ඒකයි අපි මෙතන අතර පාඩම් දෙකක් තියෙනවා incorporation and separate legal personality. And thereafter we can consider the one by one articles of association, name of the company, directors, resolutions, secretary, promoters, right? And until winding up, we are discussing one by one. right? So that is the right. Okay. Then I have uploaded a question paper also. There are 3 questions uploaded to your LMS. Now, only thing is now we can gather the facts of the topic, but only thing is we are unable to answer to the questions. So how we can answer the question? That is another issue, right? But very easily we can sort it out, be able to answer for some questions. But most probably this type of questions asked from this topic, right? Now here can we consider three, yes, only two, yes, 3 questions here. Yes, 3 questions, right? So the first one it says Amal Kamal Liman incorporate a private company by name EKN Private Limited. Then they became the shareholders and directors of EKN Private Limited. Sampath, the money lender, is a friend of Amal. After being satisfied that Amal is a direct shareholder of the company, granted a 2 million loan to EKN Private Limited. However, the company had defaulted the payments for the last 6 months due to financial difficulties. However, Sampath notes Amal has adequate assets to settle the total outstanding amount. Now, Sampath is seeking the possibility of recovering the total outstanding amount from his friend Amal. Now, he actually can the creditor bring an action against the shareholder of the company. Can go on. Yes. Oh, because of the concept of separate legal personality, right? Creditor cannot file an action against the, yes, the shareholder of the company, right? Creditor, and the second one it says the certificate of incorporation dated 5th of January 2021 was issued by the Register of Companies to ABC Private Limited. Now, already the certificate is issued to the company, right? It is issued on 5th of, sorry, uh, the date of incorporation is mentioned as 5th of January 2021, and the register has issued the certificate. Mr. Pereira, the debtor to whom ABC Private Limited, Mr. Pereira, a debtor to whom the ABC Private Limited filed an action to recover debt, came to know due to a mistake, an initial shareholder of the company did not sign Form 1 of the company. Right? The Pereira is now arguing that the ABC Private Limited cannot be considered as a legal person capable of maintaining the action against him because the incorporation of the company was invalid. Take that advice, Mr. Pereira. Can he argue that the incorporation is invalid. Therefore, there is no such legal person by this name, company's name. Therefore, the company cannot maintain this action. And he argued on that. Can't. Reason is, once the certificate of incorporation is issued, it is treated as a conclusive evidence that the company has taken all necessary steps in order to incorporate. So we need not to consider about the second conclusive evidence. This is we only rely on the first part, right? Therefore, actually, he cannot argue. So once the certificate is issued, then the conclusive evidence is that the company has taken all necessary steps in order to incorporate. Therefore, uh, even though there is a mistake happened in the registration procedure, it does not invalidate the incorporation. Therefore, the valid company is created after incorporation, and therefore the company can file an action against this person, right? It is not harm to the company because the data is issued. Mr. Pereira was convicted for a third one. Third question, Mr. Pereira was convicted for an offence of illegal drug trafficking and sentenced to 5 years imprisonment. After this punishment, he was released last year. Right? Mr. Silva, a social worker who has reliable evidence, as Mr. Pereira is conducting this previous illegal business through the company by name ABC Private Limited, and in which Mr. Pereira is the single shareholder. Right? Mr. Silva is seeking the possibility of preventing Mr. Pereira from conducting this illegal business. Can he now? What happened actually? When we consider the summary, a party who is doing an illegal act, right, by using the concept of separate legal personnel through the company, that party is conducting an illegal business. Can another party prevent this person from engaging into these illegal activities? Which type of company? If the company is incorporated to do an illegal activity, then which type of company is treated as puppet company? Right? That is now when we consider the example we have mentioned, service agreement, right? In order to violate the service agreement, they incorporate the company. So same as here, in order to do an illegal activity, right? They incorporate a company, and through the company, they are doing their illegal activities. Therefore, this is a puppet company, or sham company. The actual court has power to lift the veil of incorporation and identify who are the real owners of this company, right? And what is the business of this company? Remove the veil and make them responsible. Shareholders or the directors can be find out as the responsible parties of the company. Right? So actually, court can lift the veil of incorporation. Right? So again, that is regarding the separate legal person, not actually separate legal person, and lifting of veil of incorporation. Right? Exceptions. Right. Right. What else? අපි උත්තර ලියමුද? ලියන්නේ කොහොමද? ඔයාලා විවේකයක් කොහොමද? ඉවර කරන්න ඕනේ. විවේකයක් දුන්නේ නැහැ. ඕනේද? එකක් වගේ. මොකද දුරුද වෙනවා. මේක කරන්න පටන් ගන්න නෑ ඒක. උත්තර ලියවන හොඳයි කියලා කියනවා. මුල් කාලේ. ඊට පස්සේ අපි කරපු එක හදා වෙලා ගන්න. ඒක හොඳයි. ඔය දැන් ඕම කිව්වොත් ලියා ගන්න බෑ. ඒක ප්‍රශ්න තියෙනවා. දැන් ඒක නිකන් ඒක නම් පුරුද්දෙන් ඉන්නේ. කාලයක් තිස්සේ පුරුදු වුණාම උත්තර ලියන්න පුළුවන්. නැත්තම් නිකන් විභාගයකට දීලා ලියන්න බෑ. ඒක එහෙමම නෑ. ලියලා පොඩ්ඩක් ස්ටයිල් එකකට පුරුදු කරගන්න පුළුවන්. අපි ඊළඟ සතියේ ඒක බලමු. උත්තර ටික ලියන්න. ඕන අපි එකකට ලියමු. තවත් වෙන 35ක් ලියමු. ඔය තාලෙන් එකක්. අපි මේකේ දෙවෙනි එක බලමුද? පොඩ්ඩක් නිකන්. වෙලාව තියෙන කාලෙදි කරගන්න ඕනේ ඊට පස්සේ. අපි ෆස්ට් එක ආන්සර් කරමු බලන්න. right මේ කොහොම හරි උත්තර ලියනකොට ආයි හිත ඉන්න දෙයක් නෑ. දැන් මේක අහන්නේ separate legal personality. ඔය ඉඳන් පටන් ගන්න. දුක ගාලා ඉතින් පටන් ගන්න. හරි. right මේ මම ලියමු. right. right මේ මම ලියමු. after incorporation අනිත් එක තමයි උත්තර ලියනකොට කිදී වාක්‍ය ලියන්න. අර ලොකු ඡේද ගණන් ලියන්න යන්න එපා. ඉති වාක්‍ය පොයින්ට් එකෙන් පොයින්ට් එකට ලියන්න. අර වචන ලියනවා වගේ ඡේද වෙන් කර කර එක කොටේ ලියනකොට වගේ අර පැහැදිලි නෑ. වාක්‍යයක් කිව්වා one sentence then we can move on to next line. like point by point you can mention. right ඒක තමයි හොඳම ක්‍රමය. මේ ලියන එක. හරි. අපිට ඒ යෝගය ඕනේ කිරි පොයින්ට් එකට ලියන්න ඕනේ ඉතලා. හරි. right. අපි ලියමු after incorporation after incorporation of a company after incorporation of a company it is treated as a separate person from those who create it right comma own it or manage it. Own it or manage it. And then we can go to next slide. The next point. Right? Therefore, for the activities of the company, company itself responsible. Company itself responsible. Then next line we can say, next line. This concept is known as separate legal personality concern. Separate legal personality concern. Or we can say veil of incorporation. Right? Or veil of incorporation. When there are, you have to mention about the case laws, right? Then you can, next time you can say, example, Solomon versus Solomon company. Just mention the name. That's why I told you that is the median. If you remember the name, you can just remember, mention that. Solomon versus Solomon company. And another one is Macula. Macula versus Northern Assurance Company Limited. So like that, just cite. Right? It's always citing of cases, right? Then next slide we can say, according to the given case, the creditor, according to the given case, the creditor has given the loan to the company. Has given loan to the company. Right? Then next slide we can say, therefore, the company is responsible for the loan given. For the loan given. Right? Then the next slide we can say, even if the friend, the friend is a director or shareholder, of this company, the creditor cannot bring an action against him. We can consider the second one also, right? That is enough, right? So, second one it says the certificate of incorporation. Right? We can take down like this. Answer question number 2. Right? We can can answer like this. Certificate of incorporation. Certificate of incorporation of the company. Creates two PW two conclusive evidence or irrebuttable evidence irrebuttable evidence, right? Full stop. Conclusive or irrebuttable evidence. Right? The next slide. Accordingly, after the certificate of incorporation is issued, after the certificate of incorporation is issued to the applicant company, it is a conclusive evidence. It is a conclusive evidence that the company has taken all necessary steps. Company has taken all necessary steps in order to incorporate. In order to incorporate. In order to incorporate it under the Companies Act. In order to incorporate it under the Companies Act. Right. In the next line we can say, therefore, even if the application form is not signed, by an initial shareholder, it does not invalidate the incorporation of the company. It does not invalidate the incorporation of the company. Invalidate the incorporation of the company. Right. Next slide we can say, next slide. Therefore, this company to be treated as duly incorporated. Duly incorporated. Duly incorporated. Right? Duly incorporated. Right? Then next slide, you can say, as a legal person, duly incorporated. Right? Next slide, as a legal person, this company can file an action against the debtor in order to recover the money. In order to recover the right. We can stop it. There's one question. We see next week, right? Okay. Window